Tonight, I'm going to talk about liability issues and some issues about complaint management, specifically for home inspectors. And just to give you a little bit of idea, in terms of my qualifications, you never heard a lawyer not want to tell you all about themselves, so I certainly won't break the rule there. But I was a litigation attorney for 20 years before I became one of the owners and partners in Elite MGA. And we built a captive insurance company solely to insure home inspectors. So unlike, when you buy insurance from an insurance agency, like the other entities in the market, with us, you're dealing with the actual company. So all that money out there at risk is actually our money. And all the decisions get made entirely by us. There's nobody in an office somewhere in New York or Chicago that makes decisions on your claims. Every single claim that comes through our program, through our thousands and thousands of insureds, come directly to my desk first. And so in addition to my 20 years litigating, where I almost exclusively did home inspector litigation for most of that time in New Jersey and Pennsylvania. And to the extent you don't know, New Jersey is far and away, and I think I can probably speak for my competitors too when I say this, far and away the worst risk state for home inspectors in the country, bar none. It's a unique little animal and a lot of litigation. And so that's where I cut my teeth for 20 years, just defending home inspectors in litigation matters. And now I'm the general counsel and chief officer for claims and risk management for our captive insurance company for inspectors. And so if you need to contact me, my email address is there. If you're interested in home inspector insurance, by all means, go to our website. But I don't want to delay getting to the meat and potatoes of what we're going to talk about tonight. And I'll put my contact info up at the end. When we talk about claims, there's generally 5 types that we deal with on a regular basis. And these are the categories that I have up here on the slide. And we're talking about negligence, breach of contract, misrepresentation or fraud, violation of state consumer protection acts, and state licensing board matters. And when we talk about negligence, what we're talking about is the standard of care. And this actually, ironically, also applies to breach of contract to some extent that I'll talk about in a second. But when somebody alleges that you were negligent, what they're saying is that you failed to adhere to the applicable standard of care that a reasonable inspector in your state or your area would use in performing an inspection. And it can be statutory. So for example, if you're in a state like Virginia or Maryland that has their own state regulations for home inspectors, well, then your standard of care is going to be what's in those regulations and those standards. If you're in a state that does not have any home inspector regulations or has a hybrid where they have some kind of home inspection law, but it doesn't actually deal with the nuts and bolts standards, well, then you can use your trade association standards of practice, whether you're ASHI or INTERNACHI or whatever the case may be. You can certainly use those standards of practice in states that don't have their own. And those would all be things that would be accepted by a court. So for example, if you were in a litigation, the judge or the jury has to decide whether or not you deviated from those standards you were required to use in performing the inspection. The jury or the judge would literally look at those regulations in that state and decide based on those regulations whether or not you deviated from the standard. And how they would do that is through expert testimony usually, because you would have a home inspection expert come in for each side. And I'm going to tell you right now, there's always somebody on each side. Somebody will have an opinion that says you were negligent, and somebody will have an opinion that says you won't. And the jury or the judge has to decide who's correct or who's more credible based on their opinion. When we talk about some of the things that come up right out of the gate, the contractual defenses are primarily there. And I'm going to speak to inspection agreements and their role in liability and risk in a second. But these are the types of defenses that we generally see from your contract. And so if you've ever had a lawsuit or a claim, or if you've had to hire your own lawyer to represent you if you don't have insurance, for example, this is usually where the lawyer is going to start is your contract. And that's why those contracts are so critically important. Not just that they have the right clauses in them, but that they're state compliant for your state. so that the judge doesn't have any reason to avoid enforcing that agreement, because most of the time there's things in that agreement that can eliminate that risk and that liability right at the outset. And I can't tell you how important that is, because especially in a litigation matter, where the carrier or where you may be spending out of pocket, all of the money is in the beginning stages of that litigation before you get to a trial, called the discovery period. And so anything we can do to get rid of a case before we have to get into that is going to give you a huge, huge advantage in terms of keeping a claim from becoming something that affects your insurability or makes your premiums go through the roof. And these clauses are the type that are usually helpful in your contract in that regard. And so the most popular one, of course, is limitation of liability or a liquidated damages clause that somehow caps or limits your exposure to either your fee or some multiple of that or a flat number, whatever that may be. Those aren't enforceable in every state. And a judge is going to look at that on a case-by-case basis to decide whether or not it's enforceable. So it's not always a slam dunk. And if your agreement lacks in other required areas in your state, the judge may not enforce this part of it. And so that's why you need to make sure your agreement is up to snuff. Your clause stating exactly what your scope of work is going to be is critical, because that tells the client not only what you're going to do, but what you're not going to do. And as those of you who have been around long enough or maybe dealt with a claim or a complaint here or there know that it's usually the things that you don't do that are the things they claim you should have done, and that's what causes the claim. So it's always helpful when that's laid out at the outset for your client in the agreement. You may have some specifically contracted for exclusions based on that particular parcel or that particular building. And that's something you would want to include in the agreement. And that may, again, limit your exposure and insulate you from risk. One thing that I highly recommend that was very successful, very, very valuable to me when I was out there practicing is a modified limitations period in your agreement. Now, again, that's available on a state-by-state basis. But what I'm talking about is saying that, regardless of what the statute of limitations is in your state for a home inspection claim, you only have a certain period of time to file a legal action against me. But you have to make sure that's very specific. You need to say it's for a legal action and for any and all causes of action. There's a lot of hoops there that you have to jump through. But that's something where you might be able to limit. I'll give you an example. In New Jersey, the statute of limitations for a home inspection case is 4 years. That's insane in the life of a house, particularly in the Northeast where we have all kinds of weather, and it's ludicrous. But if you can limit that period to say 1 year, and I use 1 year because I've never really had any success getting a judge to agree to anything less, although I do know there are some laws in some states that may let you get closer to 6 months. But that's something you can use, again, to insulate yourself from liability. And then, of course, arbitration clauses. I'm going to talk a little bit about the pros and cons of those. I'm not a big proponent of the arbitration clauses. The types of documents that are going to be involved in litigation, and these are the types of documents where each one of these can play a role in whether or not there's a claim against you or whether or not you can defend yourself against a claim, and they really affect your liability and your risk. Your agreement, obviously, is first and foremost because that's the legal contract between you and that client. And so that's the primary source right there of what we're going to use to insulate you and where you can best insulate yourself. After that, it's your home inspection report. Home inspectors are professional communicators. That's your job. My job's a professional communicator for the most part, other than dealing with, deciding what cases have what values and things that I do from experience. My job as an attorney was always a professional communicator. You can be the greatest inspector in the world, but if you can't communicate to your client what it is you found in a way that gives them the impetus to take the action that they need to take or to investigate further, well, then you're half an inspector. And so your home inspection report is that vehicle. And it's maybe the only time you really get to communicate these things to your client. Your client may not be there for the inspection. And so this may be the tool that you're going to use. And so you want to make sure that it's written appropriately, that it's clear and it's concise, and it makes sense to the average American who reads at a 7th to 8th grade reading level.
Hey, Joe.
Yeah.
Hey, speaking of 7th grade reading levels, is there a problem with e-signing documents? Is
No.
that legal these days?
No, I mean, that's the norm. Whether it's I can tell you, for maybe the last 10 years or so, I left my practice in about 2018 when I joined with Elite. Up until that time, for that last 10 years, I didn't have to put fresh ink on paper for anything court related. It was fully accepted and understood that we were signing electronically on everything. And so it kind of comes, trickles down from there to everywhere. But yeah, I don't know of any state that would void an agreement for an electronic signature. And, they're really easy to prove. If you're using what I call back of the house systems, or the systems that manage your entire operation with the scheduling and whatnot. I know a lot of those provide an electronic delivery of the agreement and signature collection, and they can actually produce. So when we have a claim and somebody says, well, I didn't electronically sign that document, those providers can give me a whole printout where I can, pin it down to the iPhone that was used. And once I can prove, credibly to a judge that this was the electronic device this person was using, we usually win that argument. And so I haven't had it fail on me yet, but it's definitely acceptable by a court. I can assure you of that.
So what about signing after the inspection, but before you deliver the report?
Well, you could have a problem there. And the first one that strikes me is Maryland. I suppose we have some folks here from Maryland, right? Do we?
Maybe a couple.
Yeah.
Maybe a couple. So that they're in the licensing part of the regulations, not the actual standards, but in the licensing regulations. If I'm correct, and I think I am, there's a provision in there that says that you can have an agreement with your client to limit liability, but that has to be agreed to in writing before the inspection. So that tells me that they expect these agreements to be signed before you do the work, particularly if you're going to try to enforce a limitation of liability provision in your agreement. And, for a lot of inspectors, if you have a $2,500 deductible, and the difference of you getting out of this claim is that clause, well, you want to make damn sure that you had the agreement signed in such a way that allows you to enforce it. But I very rarely do I have a case where I'm going to get an agreement signed after the inspection was done and enforced. We try. In some states, it really doesn't matter. I can make the argument. But in a lot of states, and again, Maryland specifically, I believe they want that done before you start the work. And that, I get the argument sometimes, well, that, the job isn't done until the report's delivered. And I can make that argument. I mean, I was, half a lawyer. Anybody can make that argument, and that's great, but that's, not always likely to win the day, particularly when you're trying to enforce things that are, very detrimental to the claimant in that regard. And the limit of liability is probably the most detrimental one in these agreements that we see on a regular basis. So, and I'm going to hit this in a second on a slide, but you get that signed before you start the work. Yeah. You don't do the job without the signature. And understand there may be occasions where they got to meet you at the site. You may get a call and you might do a favor for somebody and do it within 24 hours, not really have a chance for your system or for you to get the agreement out to them for them to sign before you get there. But literally don't get out of the car. Don't put the ladder up. Don't start doing the exterior. Trust me when I tell you, I know this. I know all of you are the only ones who are ever on time for these inspections, and everybody makes you wait. But if you don't have the agreement signed, you shouldn't be doing any part of the inspection until you have that done. And I'll tell you, from an insurance perspective, most of the policies that I know of require that it be signed before the inspection takes place.
Thanks, Joe.
Yep, happy to. The other thing that's going to be critical right out of the gate are going to be your photographs. And I've been doing this long enough. I've been doing risk management seminars long enough for home inspectors that I think everybody stopped trying to tell me, there's no need to take photographs of everything because it takes too much time, or I'm more worried that I'll take a picture of something that I missed and I'm going to get myself in trouble by having that photograph. Let me please disabuse you of all those horrible notions. It doesn't take that much more time. Get a picture of every single room, how it's staged that day. And I'll tell you why. It is because these claims sometimes have a long life before they get litigated. You're not going to remember that house or how it's laid out unless you have a photograph to show you. You're going to be busy enough, I hope. that a year from now, you're not going to remember the house you did today. Okay. So the photographs are your record of what the place was like at that moment in time when you were there. Because remember, everything you do is only based on a window of time. And in the life of a house, it's a really, really, really tiny window, you know, a few hours.
Hey, Joe,
And yeah,
what do you think about body cams?
well, I'm fine with them. I think that the bigger concern with body cams are what your state's regulations are in terms of recording. So if you, for example, if you're in an occupied property and there's people there who live there and they're talking and you're picking up audio, you know, that in some states, you know, I can't remember the last one I had to look at this for. I feel like it was Illinois, but you know, in some states you need to get a waiver in advance from the people who might be in the house is the concern. And that's, you know, that's something that's, you know, can be a paragraph that they just sign off on. I don't know though, if state by state, you know, I know home inspection regs state by state, but privacy laws, I'm not an expert on, but that is the concern. I will tell you this. I had a claim this year where an inspector wrote in the report, you know, it was about a roof, and wrote in the report that, you know, you need to have somebody come out and do further evaluation on this roof. Here's the condition I'm referring to and whatnot. And then, you know, the claimant now is trying to argue that, well, no, because the inspector told me when he got off the roof that it wasn't that big of a deal, and trying to create, you know, a conflict between the messages to explain why they didn't have the place evaluated before they went to closing, like the inspector said in the report. And I was able to show, because the inspector had audio, that they were lying. They would say they were mistaken, but they were lying. So that was great. I also had a claim one time. It was a subrogation claim by a homeowner's carrier where after taking possession, the homeowner carrier insured had a leak from a standing 275-gallon, you know, residential fuel tank in the basement. And the allegation was that the inspector missed that the 3/4 copper feed line from the tank to the furnace had been compromised, and that once they fired everything up, the oil spewed all over the floor. Well, my inspector in that case, when I asked him about the claim, just happened to have body cam footage of the inspection, and he can literally see the feed line in pristine condition going from the tank to the furnace. And so that was the end of that claim. Really, I produced the video to the subrogation carrier, and that was the end of the case. So my experience with those has been limited, but it's been positive. But I wouldn't say it's the norm. And again, you want to make sure, you know, that you're on all fours with any privacy regulations or recording regulations in your state.
What about other people signing for your client? Like your client lives overseas and their realtor signs the contract for him.
The realtor, I don't know of any state where a realtor has the ability to bind a client to something like an inspection agreement without some kind of documentary proof. So, you know, generally speaking, the only party that can bind an inspection client to the inspection agreement other than the client would be the client's attorney, because they, you know, you assume that what they have is what we call in the law apparent authority, which means that it's understood that if somebody's lawyer, well, they have the ability to speak for and represent that person and make agreements on behalf of that person and so forth. But the agent's not your client. And so if your state regulation says your agreement has to be signed by the client, you're out of luck right there. And I got to tell you, I mean, look at any state regulation. It doesn't direct your duties to any agent. As a matter of fact, it directs your duties away from them. And so the person who you have no legal responsibility to, them signing the agreement doesn't do you any good. I can tell you, it would be damn near impossible. It would be really hard for me to believe that a judge would say that client is bound by the agreement that their agent signed. And that means your agreement's not usable at all. No, they can't sign it. Uncle Bob can't sign it. The brother-in-law can't sign it. The girlfriend, boyfriend may be able to sign it if they're both buying the house. But more or less, like, it has to be the people who are going to be on the deed, or how your state defines a client.
What about changing the client? to the realtor in that case.
So you make the realtor the client,
Right.
then conceivably, well, is the realtor a party who would be interested in the transaction from a financial standpoint instead of as a client? I don't know. I guess there may be an ethical issue maybe there. But I would say to you that at that point, they're doing a huge disservice to their client, because now their client has no, ideally has no means of attack, for lack of a better word, against you if you make a mistake. They've kind of shut their client out of that avenue. In addition to that, if you have a limit of liability agreement in there, and that client comes back and sues everybody, and the agent tries to make a cross claim against you for indemnity and says you were negligent, you can cap their claim at whatever that is in your inspection agreement. But yeah, no, there's no, but really, it's got to be the client. And we do. I understand sometimes that's not always possible. And I don't say this lightly. I grew up in a small business. Like, I don't turn money away. You know what I mean? Especially, this time of year, for example, or, we're in a lean real estate year. I don't tell people to turn away money lightly. But if you can't get a signed agreement, you have to think strongly about whether the job's worth it. Because, it'll be Murphy's Law, right? It'll be that one that'll be the problem, where now you don't have an agreement signed by your client. You might not have insurance coverage now. You might be in a really tough position if you wing it on that.
What about the realtor paying for the inspection?
That actually doesn't concern me as much as the signature on the agreement, because whether the money's paid on behalf of somebody or not, that doesn't make them your client for purposes of liability. The key factor really is who is the party who has the interest in the transaction and who is contracting with you for the service. If somebody else pays that on their behalf, I mean, I guess you could get into a little bit of a quagmire ethically if you're bumping up against a regulation that might say something about taking payment from different entities for the same inspection. Mm-hmm. But I think in that particular instance, that fact pattern isn't really what they're trying to prevent, because here it's not like you have, you're serving two masters. You're still going to do your job based on who your client is, whether or not the agent writes the check. And you quite honestly don't know what's going to happen at the end of the transaction on settlement day and what's going to be shuffled from column A to column B.
Right.
So it doesn't, but as long as the client signed the agreement, if you get a check from the realtor, I'm still going to be able to enforce that agreement against your client. And they're going to be the ones that are going to have the interest in making a claim.
Thanks, Joe.
Sure. The other things you want to also keep in mind that are going to come up and be part of a claim are going to be any notes you took, any emails, letters, or other written communications between you and anybody else in the transaction, and anything else you gave your client. So if it's handbooks, binders, promotional materials, all those types of things, they can be part of a case. And so you want to make sure that all that stuff, first, that the theme is consistent, right? About how you're going to do the job and what things you do and don't do. You want to make sure that all that stuff that you're putting out there is consistent. Also understand that any one of these things could be, an exhibit in a court case. And so if your emails and texts and communications with your clients needs to be tailored in such a way that you wouldn't be embarrassed by it later, or it wouldn't make you look like you're not the sound, reasonable person you usually are. And look, I mean, I have a rule, right? And so I'm speaking this from experience. I have a rule that if something bothers me and I'm responding, I have to walk away for a couple minutes and come back and look at the email before I send it. So, I encourage you to adopt that rule if you're like me and tend to maybe write something that you might tamp down a little bit once you calm down. And so just as a reminder, all these things live forever in the digital world, and they will come up in your case. And so you want to make sure that you always look like the professional you are in every communication. As far as how long to keep everything, it depends a lot on what the statute of limitations is in your state. But, in the electronic age where it's not that difficult for us to keep these things, 10 years is not unreasonable. I can tell you the oldest claim I ever got, it was for Dave Goldstein up in New Jersey. And it was an inspection that was 25 years old at the time they submitted the claim. And of course it went nowhere. But the point being, sometimes people come out of, come out of nowhere. I've had a few claims this year where somebody's selling the house and the inspector who is inspecting comes to find that there's a stucco defect and there's damage in the interior cavities. And, and they come back now that they're the seller, they're first learning about this. And now they try to bring a claim against the inspector, who did the inspection for them 10 years ago. And we get those types of claims. And I'm going to tell you, there's states that have what we call the discovery rule, where they take whatever the statute of limitations is, and they say it doesn't start to run until the claimant had reasonable notice that they may have had a claim. Well, these people wouldn't know what's going on in the walls until somebody told them the stucco was defective. They didn't see any staining, but lo and behold, the rot was there and the stucco defects were visible. They might get that claim across the books. They might get that claim in the court. And so you want to make sure, I can assure you of one thing, the one document that they won't have after that many years will be the agreement they signed that said they capped their damages at the cost of the inspection. That will conveniently disappear somehow. And so you want to make sure you have it. Because that may be critical in diffusing that whole claim. But so if you can keep them, keep them. If you can't for whatever reason, I would say at least use the old IRS rule, 7 years. And your state, and it's not on the tip of my mind, but I know that the regs, sometimes the state regs say you have to have everything for X years, and I can't remember. I apologize, I can't remember if that's in the Maryland regs or not. It's definitely in a couple of the other states for sure.
It's 5 years, Joe. in Maryland.
5. Okay, so there you go. So I would say at the minimum, you have to keep it 5 years there. I'm going to tell you, if you can keep it a couple extra years, it wouldn't hurt. The damages that are usually claimed in the claims that we deal with inspectors are this list here. Repair costs obviously being the most prevalent. Relocation costs, and what I mean by that isn't like moving. What I mean is if they have, for example, a significant structural defect, then I got a house in New Jersey that's twisting off of the side of a cliff. They're not going to be in there when they do the structural work to repair it, so I'm going to have to pay to put these people somewhere. So that can be part of it, if they have to go stay somewhere. Replacement costs. That usually comes up when we have what we call a general liability claim, which is not where you were alleged to be negligent, but where, let's say you're doing the inspection and you knock over a vase. Of course, it's going to be an antique vase worth millions and millions, if not priceless, when they make the claim. But, that what I'm talking about is replacing that if it gets broken. In some instances, they can claim a diminution in value, or just meaning that whatever the defect that you missed is, it's made the house less valuable. But usually that's obviated by repairs. And so that condition doesn't exist anymore. But I still have people try to claim that if a home ever had mold, for example, that's an automatic diminution and a stigma. But I have yet for anybody to actually be able to prove that to me. And then if you violate a state consumer protection law, you may be hit with treble, or what we call triple damages, or attorney's fees. A lot of the state consumer protection laws have clauses in there that say, if it's proven, you have to pay 2 times or 3 times the actual damages, and the other side's all their fees too. And that can be insane. And also that's not covered by any insurance. And then statutory fines. If you're in a state that's regulated, you can be disciplined, and sometimes that involves a fine. And so that's the type of damage that you might incur as part of a claim. But these are generally what we see. And I'm going to tell you that 90% of everything is going to be repair costs. That's usually what I'm dealing with in my world. I just wanted a couple of factors that come up in with liability and particularly with claims, or what I see. So before, I did a claims assist program where I did help inspectors all over the country manage pre-litigation claims. But most of my litigation work was PA and New Jersey, and sometimes Delaware. But now that I've been doing this, actually seeing the claims across the country for several years now, there's some commonalities that come up in claims over and over again. And when I'm talking about these, I'm talking about the ones that actually have some meat on the bones, not the frivolous stuff. Failure to document obstructions to visibility or to the ability to inspect a system or component. That's a common theme in claims. where the inspector, isn't effusive enough or doesn't have photographic evidence or, doesn't really explain that they couldn't enter the crawl space all the way, or that they couldn't get through the entire attic because it wasn't all walkable, or, that they can only see part of the basement because of finished surfaces. And so what happens is, a lot of times the inspector will, like, I'll get a report that says, attic inspected. And then the inspector says, and the claim is about something that was in the attic that may have been visible if the inspector could reach it. And the inspector doesn't have a photograph and it's been 2 years and can't tell me what the obstructions were or why they didn't go through the whole attic. And it makes it very difficult. And so, when you think about obstructions, like, I can't get up on the roof because, let's say you're an inspector that usually gets on the roof and you can't get on the roof because of snow. Well, it's not really enough to just say to your client, I didn't get on the roof. Like, you have to say why, because that's a system or component that would normally be inspected. And so you have to tell the client why it's not. But I would also go the extra mile and say, here's what I can't inspect as a result. Here's the components of that system that I'm not going to be able to put eyes on. And if you have concerns, you might want to have that all looked at before the end of your inspection period, if that's possible. I don't, it depends on what the weather's doing or how long they have, but, maybe give them the impetus to think like there might be some more there they should look at before they spend hundreds of thousands of dollars on this house. I still get a lot of claims with inadequate or incorrect estimations of repair costs. And, I'm going to say to you, if it's something that you do as part of your work, my advice is always, and I know it sounds pithy, but be right. Use reliable sources. Make sure you're verifying those sources. Make sure you're updating things if you're using, stuff you downloaded to your computer. If you're using Xactimate, you might think of that, like, and making sure that's programmed correctly. But if you're going to give estimates about what things might cost, you need to have a really good resource for that. I know there's some resources out there that are available. I get peppered with emails all the time. I'm sure you do too. But that you definitely want to think about being able to do that. Now, look, if that's your business, if you're in construction and you know this stuff, well, if you trust yourself as a resource, that's okay too. But just make sure you have a valid resource. And then the other thing is, I see a lot of confusion in reports, and some of it's just based on the way the software that you're using is. But there's this multi-stage, multi-tiered hierarchy of defects. I might get to that in this set, but you're there to look for material defects or defects as that's defined by your regulations. And when you have all these confusing terms and 12 different ways to define what it is you're looking for, well, the reader gets confused. Again, 7th to 8th grade reading level, 13 to 14-year-old vocabulary. You're not an Eskimo. You don't need 50 words for snow. A defect is a defect, and I would say limit that universe of terminology as much as you can to avoid confusion on the part of the reader, because confusion is one of the things that leads to claims. And so that's what I was talking about when I said the hierarchy of defects. You should avoid that model of reporting. Really, you're looking at, in any state, generally what you're there to look for are issues that substantially affect the value, the safety of people, or the habitability, and those are really the three criteria that make up what's a defect, or what I would say to you, even more importantly, what the general public and what judges expect you to report, in addition to what's in your standards. And so value defects are easy to define, right? Well, I have a roof problem, I have a leak, it will cost $10,000 to repair this condition. Well, that's easy. That's an easy value defect, and we can measure that. But safety and habitability might more be, subjective, and you need to be objective about that. So remember that what might be significant or insignificant to you may be significant to your client. And the safety and habitability issues are, the ones that usually make up a very narrow window of claims. Mostly it's about value caused by a defect. I said before, we have, people read at a 7th, 8th grade reading level. So you want to make sure all of your communications in the report and in the agreement are written in such a way that the average person who knows nothing about residential construction can read through that document and understand the differences between the systems and components that you inspected that are there at the property, and to identify significant safety issues that are visible and accessible to you. And again, if the more photos you can use, the better. The last thing I was going to say here is, the one thing that always confuses me, and it comes up a lot, particularly when we're dealing with structural claims. I get a lot of claims still where an inspector goes in, let's say it's a block basement, foundation. I'll get a lot of reports in on a claim where it says, there's cracking here. You should monitor that to see if it gets worse, or something to that effect. And I really don't think that really does much, when we're talking about structural defects and things like that. I don't know that that's the best advice you can give your client. And again, that's based on my experience seeing how that plays out, because they don't understand that to mean anything. When you tell them monitor, they're not going to ever go look at that thing again until the wall's bulging and falling down. They're never going to go look at it. And so if we're thinking about the value of your advice and giving people information they can actually use, I think avoiding monitor when we talk about structural defects is probably a good way to go. If it looks like something that you're concerned about at all, perhaps it's best that they have somebody else look at it. Or perhaps you could give them advice. There's no harm in giving your client homework and saying, these cracks they may not be severe now, but you can inquire of the seller whether or not they know about these, have they ever made repairs in this area, and so forth. And you may get the information there. But I would say, when use monitor sparingly. And if it's something that you're concerned about, think carefully about whether it's something that triggers that next duty of yours, which is to tell somebody when they need another set of eyes on that problem. Oh, we talked about that one already. Sorry. Sorry, folks. Somehow I duplicated some slides in there. The other thing that comes up from time to time is the idea of using what we call technically exhaustive measures. And so, for example, I got a couple claims in over the summer where the allegation was, it's always some other contractor who tells people what you were supposed to do or how you do your job. And it was always roofers that threw you under the bus more often than not. Like, I just used to call them the Greyhounds, but the HVAC folks are making a run for their money and throwing you under the bus, and the waterproofing folks. And so I got a bunch of claims in that say, where somebody's telling your client, well, they could have used IR here and they would have been able to tell if there was a moisture problem in the walls, and that, that's something that home inspectors do. Oh, your inspector didn't do that? Or, when we have a sewer waste line problem, away from the home, underground. And the plumber says, well, home inspectors, they have sewer cameras and they can just put that in there. They could have done that for you and told you if you had a problem here. Those are obviously technically exhaustive means of performing your inspection, and you're not required to do that under any known standard. I don't care, state, association, whatever the case may be. It's just not there. But things do start to become the norm, right? And so, for example, if you have enough inspectors in enough states, let's just use IR. If enough inspectors in enough states were using IR over and over again as part of their inspections, that's going to bleed into a little bit what the standard of care may be in that state. Now, regulations are always going to trump any of that. So if you're in a state that has regulation specifically says you don't have to use technically exhaustive means, well, that's going to trump anything that comes up later, or no matter what anybody does, as long as it's not considered technically exhaustive anymore. But once it's not exhaustive, once it's a norm, it could be shoehorned in there. But as of now, really, other than, I can think of some things off the top of my head that are required in states, a gas sniffer, a moisture meter, a certain size ladder, a certain size light, something to probe with, and then anything else that each other state might require. Other than that stuff, anything else is technically exhaustive and generally doesn't apply. I had this engineer in New Jersey on a bunch of cases when I was still practicing, and he would write these reports about what the home inspector was supposed to see. And he's out there using like laser levels. He's got this, array of scientific equipment, like it's Jacques Clouseau, except, he's above ground but or above water. But what, again, none of that stuff matters because a home inspector isn't going to use any of that stuff. That's not what your job is. That's not what you're paid to do. That's technically exhaustive. And so, I listed a few here that we deal with. Drones are the other one. Your inspector could have used a drone to see this. Well, you're not required to use a drone yet. But they are being used more regularly. I can tell you that much. Some of the claims issues that we routinely come up against, and these can affect your insurability and your premium as well. Now in our company, we don't count things as claims unless I have to write a check. And so you can report everything to us. We encourage it, actually. We like the work. Now we encourage people to tell us everything, and we want to help you with everything because there's a great chance that we may be able to knock this thing out before it ever goes anywhere. And we don't count those as claims against you. We call those incidents. None of those are counted. The only time I count something, and even if we help you and we get a release signed, if it's not our money, well, then that doesn't count as a claim in our program. And so we do a lot. I always say we may get hundreds of claims. I get thousands of incidents that we deal with on a regular basis that we prevent from becoming claims. And so we don't penalize you for doing that. And so we don't get it as much anymore because now the people who work with us are used to the idea to tell us everything because we're not going to hold it against you. If we have to write a check, well, then it could affect your premium or your insurability. But if we don't have to and we just have to help you get rid of it, well, we're happy to do that. But frequency and severity of your claims can definitely be a factor in whether or not you can get insurance and get it at a reasonable price. Defense costs. What used to drive me insane is when I started doing the claims versus being the litigator is I would get these claims in and the attorneys would bill $40,000 or $50,000 on that file. It's in litigation and they're going to depositions and they're doing all this stuff, and that's great. And they have to defend you. I get it. But then the claim settles for like $5,000. And I gotta wonder like why it didn't settle at the beginning for $5,000. Now sometimes you do have to force people. Sometimes you have to go through the motions and file something with the court to get the case dismissed and fight that and fight an appeal. And we get those, and that's going to happen no matter what you do. We're in business to pay claims. We pay. We know there's going to be claims that are legitimate or they're going to require a defense up to the very end. But when I see stuff where the lawyer would ring up these giant bills and the claim would settle for peanuts, because that number is the same for you whether they paid 50 on the indemnity or 50 on the defense. For most carriers, it's just 50. And they count it the same against you. So if you have bad representation, that's actually held against you when they take that claim and decide what to charge you next year. I got rid of all that with our company because having done this for 20 years, I can tell right away when I look at one of these bills where somebody's just running up a ticket. And we don't have it in our program. Every attorney that works on our cases in every state in the country is handpicked by me based on my 20 years of doing nothing but home inspection. But that's another thing that can really jeopardize your insurability is bad attorneys.
Hey, Joe.
Yeah.
If an insurance company settles for less than the deductible, is that considered a claim with you guys?
With us, no. No, because I don't have to write a check. So if I'm not spending my money and you say, well, first of all, in our program, unlike a lot, our adjusters aren't allowed to settle the claim unless they have your consent. They just can't decide what's best for you. You always have a say and you can withhold your consent. There's nothing we can do about it really. So our insured always has to agree, first of all. But if our insured says to us, I want to get rid of this, and let's say it's for, let's say the limitation of liability in the agreement says $1,000, right, for purposes of this, and you say I want to get rid of it, and that's within your deductible, I'm going to write the release. We're gonna get that cleared with you. We're going to negotiate it. We're going to get it all done, locked up, and tied up in a nice bow. And then that's never going to go anywhere because we didn't have to write a check. And so we don't count that against you. You can have, I mean, trust me when I tell you, I have insureds of ours that they may get 50 of those a year. They have a lot of inspectors. They're busy, but not one of them turns out to be anything that I got to actually spend money on.
So do you guys review existing agreements that inspectors have?
Yeah, so I did for a few years before I stopped practicing. Dave Goldstein and I had a company called inspectioncontracts.com. And so we had sold contracts for every state in the country. So now for our insureds, if you're insured with our program, we not only do we provide you with an agreement for anything for free, that I wrote myself, but in addition to that, we'll also review yours and make modifications or help you with yours however you see fit. Look, I mean, I may be a lawyer, but it's your company. And so I always feel like I'm not going to tell you you have to use my agreement. I'm happy if you're using yours. And if I can help you make it a little bit better in some regard, then I want to be there to do that. So we often do that. And I get insureds that come to me with stuff that's unique, that fits within their coverage. And so in those occasions, I'll draft a contract for them if they need it. And the release agreements we do, of course, all the time for every state as well. But yeah, no, I look at, just like I look at every single claim, all the agreements that we review for our insureds are reviewed by me, or I actually have another attorney who's also an adjuster on our staff that looks at them as well. And what we're looking for is A, that they're state compliant with your state, and B, that they have the proper things in there to help you and insulate you. And I guess C is that they're readable by the average 7th, 8th grader. And so we try to keep all the legalese and that kind of BS out of there as much as possible.
Yeah. Yeah. Are those release of liability documents signed by the clients respected by the courts if the client makes a second claim? On the second claim? Yeah.
Yeah, absolutely. But understand they have to be written appropriately, right? Because they're just like your inspection agreement. A release is a contract. And it's a contract between you and this other party, and it has terms and it has consideration, which is the money that's being paid. And so it has to match up. It has to be an enforceable contract. And if it's missing, certain required terminology, it can be detrimental. So, I'll give you an example. I had a guy, it was a week before the holidays, says, he turns in a claim. He says, well, I got this person dead to rights. Here's the release I had him sign, and they don't have a claim here, and you can get this court case dismissed. Well, the release doesn't say that it releases any claims known or unknown. And this is something different than what he paid out on. So he's not protected by that release. It's critical that the release specifies in gory detail that it's a release of all claims known or unknown related in any way to this inspection or any of the services that you provided to that client at that address. Because otherwise, you could settle and say, well, I settled with them for the leaky roof. Now they're coming back and saying there's plumbing defects. Well, if your release didn't release claims known or unknown, you didn't release the plumbing claims. And so now they're going to come back to you. So that has to be in there. And it has to meet all the definitions of a basic contract. And so that's why those things don't change much from state to state, which is great. And they don't have to be War and Peace. It can be a very simple document. And we try to make those as simple as possible. So nobody can ever say they didn't know what they were signing when they signed it. We never want the consumer to say, well, the big bad insurance company or the big bad inspector, talked me into signing something I never would have agreed to. Well, it's crystal clear, ours is, and it's for that reason, because we want it to be enforceable. But yeah, just like any other contract, it's enforceable by the courts, but it needs to be written appropriately. And so I see a lot of releases that are written bad and agreements that are written badly, or they're combo meals of like 6 different agreements from 6 different people. It's better if you have something very concise and appropriate.
So Joe, we got a late start.
Yeah.
Can you wrap it up in 5 minutes?
Oh, absolutely. Absolutely.
Thanks.
Let me just see, because some of the stuff we already talked about. Sorry, I didn't know that transition was still there. Let me just skip through here. I want to talk briefly about auxiliary standards because this comes up a lot.
I've never seen you go through your whole PowerPoint.
I've never, I have a joke at every one of these. I always say I roll in there with like 100 slides for, if I'm doing like 3 hours, I get through maybe 15. And that's awesome though, because that's how I know, I know the slides are effective because it generated, some back and forth. And that's, that's real, especially in, since COVID, where we're doing a lot more of the remote stuff. I can't see the faces, right, all the time. And so the only way I know I'm reaching anybody is with questions. And so, yeah, I rarely get through them. And even now it's tough. But this one I definitely wanted to talk about because it's coming up a lot, and about whether, you have an inspection agreement, but what about all the other services you're doing? And again, I give these free darn short, so I'm not trying to sell them to you, but the point I'm trying to make is that, it really is important that you have a separate agreement for these ancillary services, because the standard is completely different than what your home inspection is. For example, I actually love, by the way, that I got to hear not only about, the crawl space issues today, because I see that every day, but the radon stuff too, because it reminded me, that's, if we were talking about that in terms of a home inspection, that's technically exhaustive, right? And so the standard for that and what you might do in that service is entirely different from home inspection or mold inspection, where you're actually going to agree now to do something that your standards for home inspection say you definitely don't have to do. You need to have a different agreement with a different set of standards in there for that service. Because otherwise, you're kind of winging it on what your client understood that service to be before they bought it. So it's not enough to put that charge on the inspection agreement. You need to have something in writing that lets that client know what it is you're doing for them as part of that other service. And so I wrote ancillary service agreements for everything I could think of. Sewer camera, IR, whatever you can think of, lead, meth labs, whatever the case may be. And we made them short, like addendums that people could just tack onto their home inspection agreement, because a lot of these agreements are just repetitive. They say the same things over and over again. So you pull out the heart of the ancillary service thing and add it to the inspection agreement, and it keeps it from being, this gigantic long document that your clients have to read through. But you should definitely think about having an ancillary service agreement for any ancillary services you do. And if you use any subcontractors at all in your business, please get a signed agreement with them. They don't owe you anything without a contract. And in particular, you want that contract to make sure that they're carrying insurance, because unlike you, they're not regulated as much. And they may not have insurance. You want them to have insurance, and you want them in writing to agree to indemnify you and hold you harmless if there's a claim related to services they're providing. Whether or not you're charging for it and hiring the sub, or your client's hiring the sub, have an agreement with them that sets out the parameters of who's responsible for what. Because if they have insurance but they don't have a written agreement with you, there's a good chance their insurance isn't going to step in and indemnify you for their bad actions. And you want to make sure you're an additional insured on their policy. Now, the subcontractor agreement that I wrote that we provide to all of our insureds, also, I put stuff in there to protect your business, so that they can't, for example, if you're using subcontractor home inspectors, they can't raid your client list or your referral sources. Or even if you're using somebody to do mold or another service other than home inspection, you don't want them contacting your clients or abusing that privilege of doing the work on your behalf. And so we incorporated that into our subcontractor agreements. But please, if you're using a sub, make sure you have an agreement with them, definitely and without a doubt. Well, I certainly, again, appreciate everybody letting me come. I want to put my contact info here because I know sometimes you can't get the questions in. Again, our website, eiipro.com. You go there, you'll find out everything you need to know about our home inspection insurance company. Our national sales manager is Ben Garrison. at Elite MGA. If you don't know him, he knows a lot about this business and can put you in the right place. And then again, my contact information is there. I manage mostly claims and these types of presentations, but if you have a question, by all means, shoot me an email. I'm happy to respond. And Hollis, thanks so much for asking me. I really appreciate it. Like I said, I got a lot more out of this than people might think. And so thank you very much for the opportunity. And if you ever need me again, I'm happy to be here.